Namaste. Good morning, good evening, everyone, and depending on which time zone you're all logging in from. My name is Anupama. I'm a corporate attorney and mediator accredited in the US and in India. It is my privilege to host this webinar today and to welcome all of you to today's program. Today is the third session in Team Nivaaran's fourth edition of the International Summer School of Mediation. As many of you know, this initiative was started in March 2020, and despite the pandemic, the initiative has gone on every year with this summer school program. Thanks to the effort of the main team and the enthusiasm shown by the participants from around the globe, the program is becoming more popular each year. This year's program is being conducted in collaboration with the Singapore International Mediation Center and Commonwealth Lawyers Association. The chief guest for today is Ms. Dapaah from Ghana. She's the Deputy Attorney General and the Deputy Minister for Justice. Ma'am, it is an honor to have you with us this evening for Team Nivaaran's program, and my personal privilege to welcome you to this program. The aim of the Team Nivaaran has been to educate everyone about mediation, the art, the science, and the skills of mediation, and teach mediators the nuances of mediation. The program aims to bring experts in mediation from around the world so we understand how mediation is doing in other countries and cultures and learn from them. Today is the third day of this year's program, and if I'm not mistaken, it's the 27th session in the 4 years. The session run from 22nd July to 2nd of August, when we will have the closing ceremony. Before I talk about today's topic, I would like to briefly introduce our chief guest and panelist for today. I hope I will do justice to her introduction. Her list of accolades is very long, but I will try to pinpoint some of the main ones. Ms. Dapaah, she's the Deputy Attorney General and Deputy Minister of Justice since June 2021. Prior to that, she was a lecturer in the Ghana Institute of Management and Public Administration School of Law from 2011 to 2021. She's also a World Bank certified trainer. She's also worked with the Office of the Chief Justice of the Republic of Ghana and obtained an LLM from the Fordham Law School in New York. She's a member of the Ghana Bar Association, Ghana ADR Club, and Ghana Arbitration Center. She has made numerous presentations in the field of alternative dispute resolution and human rights. She was also awarded as one of Africa's 50 most promising young arbitration practitioners. She has also received many awards during her college years. Ma'am, I welcome you today.
Thank you very much.
Before I request Ms. Dapaah to take the floor, I will just mention briefly the topic for today's webinar, which is the definition and process of mediation, the difference between mediation, conciliation, arbitration, and litigation, the lacuna and disadvantages of the adversarial dispute resolution system. Mediation seems to be the buzzword nowadays around the world when we talk of dispute resolution. And in India, it's gained great momentum, especially in the past few years. Nowadays, the mediation bill is also being talked about in India, which will be tabled this year in the Parliament's monsoon session. While litigation and mediation seem to be very different, many have used the term mediation and conciliation interchangeably, but there is a stark difference in all the four mediums used for dispute resolution, whether it is litigation, mediation, conciliation, or arbitration. I, along with everyone who has joined us today, look forward to hearing from you, ma'am. And after the presentation, there will be a Q&A session. I request everyone to post their questions in the chat box, and we will take them up one by one after the presentation. Ma'am, over to you now.
Thank you very much, Anupama, and I would like to use this opportunity to send you very warm greetings from your friends here from Ghana, and to thank the organizers for this very wonderful and I believe very imperative training program for all of us who are interested in the justice delivery system, wherever they may be, as litigants, as lawyers, as judges, as the case may be. And I like to see some of these training as an interactive session. And as I tell people wherever I go, that in as much as I'm here to share some insights with you, I'll be very happy to also learn from all of you. And so I look forward to the Q&A sessions, particularly to add to my own store of knowledge. As you recall, I have been a lecturer for over 12 years now, and I like to take new things wherever I go and then show them to my next part. So they think I'm very clever, but not knowing that I'm actually tapping into the experiences of other people. So please feel free to engage me and join me as we go through the next 30 minutes or 1 hour of our session. Now, as Anupama rightly indicated, today is just to give you an overview of what mediation is about, the processes, and then look at it in comparison with other forms of dispute resolution. I'd like to start off by saying that mediation, from where I sit, is noted to be one of the many forms of a general spectrum of what we call alternative dispute resolution. Alternative because for us in Ghana, for instance, we even like to say that ADR is actually African dispute resolution, because before litigation became the general or normal way of dispute resolution, we were used to other forms of dispute resolution. Particularly in the olden days, you have community heads or chiefs who would help settle some of these processes. And so mediation has come to be known as one of the forms of alternative dispute resolution. Now, a bit about the whole advocacy for other forms of dispute resolution like mediation. The story is usually told of the hospital setting, where it is found that if you go to the hospital and you have an ear problem, you're likely to go and see the ENT specialist. If you have issues with gynecology, you are likely to go and see the gynecologist, the obs and gynae. If it's about your kids, you're likely to go and see the pediatrician. And so it is told that there cannot be one form fitting for resolving all types of disputes. In other words, litigation cannot and ought not, and is not the appropriate mode for all types of dispute resolution. Just as we have specialists for particular kind of ailments, so it is with disputes. Some disputes are better resolved through other forms of dispute resolution other than the default litigation that we know. And so today I'm here to actually advocate for mediation, because I am a believer that there are certain disputes that may be resolved through other means of dispute resolution other than litigation. That said, let me quickly share my screen with all of you. And so Anu rightly gave you the outline for my presentation today, which is to introduce you to mediation, look at what the definition and process of mediation is, the differences between mediation, arbitration, and conciliation and litigation. And then we end off with looking at the lacuna and disadvantages of adversarial form of dispute resolution. Now, what is mediation? I think, as most of you are aware, mediation has various kinds of definitions, but we'll find out that no matter how mediation is defined, certain elements are common with all the types of definition. Now, mediation is defined from my end as a type of dispute resolution, which involves the use of a third neutral party called the mediator, who assists the parties to negotiate a mutually beneficial agreement to their dispute. And so from this definition, you also find other definitions like the UN Convention on International Settlement Agreements, the Singapore Convention, now also defines mediation as a process irrespective of the expression used. I'm trying to use the slide. Okay. Yes, great, this is better. It defines mediation Article 2 as a process irrespective of the expression used or the basis upon which the process is carried out. whereby parties attempt to reach an amicable settlement of their own dispute with the assistance of a third person or persons called the mediator or mediators. Now, it emphasizes this, that mediator lacking the authority to impose a solution upon the parties to the dispute. Now, from these main definitions, and there are a number of definitions there, what it's common among all of them that, first of all, there's a third party neutral, and that third party neutral is called a mediator. Again, that third party is not a judge, is not an arbitrator, lacks the authority to impose solutions on the parties, but only helps them, the parties themselves, the disputants themselves, to negotiate their own amicable outcome of the dispute. And so what are some of the key attributes of mediation? I've listed a number of them. You could have some based on your own understanding at the end of the session. Now, mediation sometimes is even called assisted negotiation or facilitated negotiation. And with that, what we mean is that the mediator, unlike what we know in the court system where a judge drops his or her gavel, imposes decisions on the parties, the mediator only assists the parties to negotiate themselves, only facilitates the process of negotiation. And then the mediator usually does that by using some skills, which I thankfully have seen as part of this training that you learned, some really key communication skills, such as active listening, questioning skills, reframing skills, reflecting skills. And so because parties are there because they have failed perhaps to be able to negotiate their own disputes and come up with a resolution. And so he helps them both based on the skills he acquires as a mediator to assist the parties to come up with their own resolution. And so clearly is underscored that a mediator is not a judge. The mediator does not make a decision or take a decision on behalf of the party. He's only a facilitator. He's not a lawyer for any of the sides. He's not a negotiator himself. And like the UN, the Singapore Convention rightly indicated, lacks the authority to impose a solution upon the parties. Another key attribute of mediation, just like most ADR forms, is that there is a considerable amount of party determination. And by that, what we mean is that parties themselves determine the process, the procedures, the settings of the mediation setting. And so parties are supposed to be part of the whole process of mediation. In fact, in Ghana, I think when we started this whole advocacy for mediation, some of the problems we identified is that parties felt very alienated from litigation, the whole litigation process. Some will tell you that, look, sometimes I sit in court and I do not even know what is going on. All I see is the lawyers and the judges speaking their legal lingua, and the rest judicata and nemo judice non causa, and you get so confused, and sometimes you wonder if it is your dispute that they are talking about. You wonder if it's your case that is being handled, and sometimes you're not part of the process until the case is closed, and then you now have to chase your lawyer and find out what exactly was going on. What did the judge say? I don't understand. With mediation, the process allows parties to actually be part of the process, to feel, to own the process, and to arrive at their own dispute resolution. Another key attribute of mediation is that it's also voluntary. Now, this has lent itself to considerable debate even in Ghana, because if you look at our part 2 of our alternative dispute resolution at 2010 at 798, you will find that the court can compel you to go to mediation if you look at section 64. But generally, parties themselves choose to be part of the mediation process up until the time when they want to settle that matter. And so it is argued that even though in our act, the court can compel you, the court may make an order that parties should attempt mediation through the ADR offices that we have connected to all the courts. But you are not compelled, once you attend the mediation process, to arrive at a settlement. Up until the point of settlement, parties may walk away, even though it is recommended. And usually with the skills of that very skillful mediator, you find out that Once parties relax into the process, take charge of their own dispute resolution process, they are most likely to arrive at a settlement. Another attribute of mediation is that it is private and it is confidential. Now I'll explain what private is and I'll explain what confidential is. Mediation is private because it's only the parties and the mediator and any other person whom the parties consent to be present that is present at the mediation process. Again, normally when we describe this, we look at it in conjunction with how the court settings are. You know, as I sit here in Ghana, I can just walk and sit in any court and hear any matter, any secret concerning any dispute without being told or driven away from the court premises, because court hearings are very public, except some few cases where for social policy purposes like children matters, divorce matters, you find the parties meeting in the chambers of the judge. But other than that, generally you can walk into any court and listen to any proceedings for the day, and then you get to know what is happening in people's private lives, which have now come in the court. Unlike the mediation is very private, it's only the parties and the mediator and any other person whom the parties have consented to be present. And so you realize that most companies who would like to have certain secrets, certain corporate secrets, certain trade technologies that in the court would prefer another form of dispute resolution that protects some of these trade secrets and these sometimes even the challenges that they may have in their corporate institution and even private persons as well. Again, mediation is confidential because anything said at the mediation process shall not be divulged to persons outside the mediation process. So just like the court system where you get to know what is happening in people's personal, financial, corporate lives. Once anything said at mediation process is confidential, even it's what we call without prejudice. Before that, it's confidential because if there is any admission that is made, which would not have been made but for the mediation processes, those admissions, those information that come out at the end of the mediation process cannot be divulged outside the mediation process without the parties consenting to that. Another key attribute is that mediation is without prejudice to parties' rights and liabilities. In other words, in where mediation fails, in the unlikely event that mediation fails and parties have to end up in another form of dispute resolution, for instance, litigation, you cannot use statements that were made, admissions that were made in the course of the mediation process against the party in court. So for instance, as I indicated, the Ghanaian courts can compel you to go to arbitration. And normally they'll give you, let's say, 30 days to attempt mediation through the ADR offices. Now, when mediation fails, in other words, parties are unable to arrive at an amicable settlement within the 30 days, they may extend the time. But if the courts find out that the parties are unable to arrive at any amicable settlement and they come back to the court, usually the court, the judge do not try to know why they couldn't arrive at an amicable settlement because of this without prejudice, right? He only find out if they were successful in reaching an amicable settlement. If they were not, then he proceeds to set a date for trial or the hearing of the matter itself, without determining who is at fault, who was being difficult during the mediation process, etc. And so the mediation failed. So how is mediation, the process, how does it start? Usually parties themselves may submit to mediation in a form of agreement, whether written or even oral. And it can happen before the dispute or after the dispute. Before the dispute, usually parties in contract or agreement may have different types of dispute resolution process, including sometimes double or triple tier. For instance, parties may say, if there's a dispute between us, any dispute arising out of this agreement, we'll first attempt negotiation. If negotiation fails, we'll then attempt mediation. Or if mediation fails, we'll go to arbitration. But usually the submission to mediation can be through the parties' own agreement. As I've indicated, in our part here in Ghana, the court may also refer parties by reason of the ADR Act of Ghana 2010 Act 798 to mediation. And of course, we have also other statutory statutes that compel mediation, other specialized statutes in Ghana. For instance, if you look at some issues on dispute, family matters, you can be compelled by reason of the statute regulating that process to go to mediation. And usually when the parties arrive at mediation, it's usually an invitation to depending on whether it is the mediation is being run by an institute or is being run by, for instance, an ADR office, or a mediator has been appointed by the parties. He invites the parties. Usually there's the opening statement, which for me is a very key component of the mediation process, because it is the opening statement where the mediator introduces the parties to himself or herself and to themselves as well, and then explains to them what the mediation processes are, and then sets the ground rules, that there will be no interference, there will be decorum and courtesy in the form of communication. And it's also at the point of the opening statement for me is very key, because it also sets the tone for the mediation process. It enables the mediator to carry out the assurances that the parties need, among other things, that the process is private, the process will be confidential, the process will be led by the parties themselves. They should feel free to vent, they should feel free to come up with their own propositions for settlement. And then the assisted negotiation itself takes place, which is where there's a back and forth negotiation between the parties, and possibly there's a settlement agreement, which is the final outcome of the mediation process, and may be used by the parties as the resolution. So the effect of the settlement agreement, let me say something briefly, differs from country to a country. For us in Ghana, if you look at our Section 82 of the ADR Act, it is clear that where a settlement agreement is arrived at, a binding settlement agreement is arrived at the end of mediation, the Act says that it shall be enforced in the same manner like an arbitral award. And then it refers you to the arbitral award in Section 57. If you look at the arbitral award, you realize that arbitral awards too in Ghana are enforced like a judgment of the court. So what does this mean? It means that when there's a settlement, a binding settlement agreement arrived at in the course of mediation, for us in Ghana, you do not have to start the whole process and only use the settlement agreement as evidence. Rather, you enforce that settlement agreement in the same manner like you enforce any court judgment, like through all the processes of Faife, Ganishi, as we know, when you obtain a court judgment in your favor. Now, quickly, very mindful of my time, let's look at a number of the differences between mediation and other forms of dispute resolution. Don't forget, I told you that dispute resolution, in my humble opinion, must not have one cap fitting, or in other words, there should not be one form of settlement of disputes, because, like I told you, certain elements require certain specialist and specialized process to handle them. We'll start off with mediation and conciliation, even though I must point out that, and Anupama rightly stated, most people use these terms interchangeably. For us in Ghana, the ADR Act of 2010 Act 798 regulates arbitration, mediation, customary arbitration, and that's for the topic for another day, because like I stated, we Ghanaians continue to believe and cherish in the pre-colonial forms of dispute resolution, where chiefs and other respected elders, through custom and culture, were able to resolve disputes within their own ethnical community. And so the Act still regulates customary arbitration and makes these chiefs and leaders, when they sit as customary arbitrators, to make their awards that they come up to us like a judgment of the court. But that's it for another day. But we do not, the Act does not make provision for conciliation. And it's arguable. Sometimes people use the term mediation and conciliation interchangeably. Again, through both processes also require the use of a third neutral, impartial party called a conciliator. But usually people like to say that conciliators have much more active role in the course of conciliation, and may in some circumstances even come up with draft proposals for settlement and for consideration by the parties. And also mediators, as I indicated, only facilitators, and may not have that level of activeness that a conciliator have. And usually conciliators arguably also shuttle between the disputants, especially where it's very difficult to get all the parties together. And so quite some substantial similarities between mediation and conciliation. And depending on where you're coming from, your act may specify the various attributes, the different attributes between mediation and conciliation. But as I've stated, we do not have conciliation as part of the processes under our ADR Act. I'm aware that there's, as you mentioned, there's an Arbitration and Conciliation Act in India, and I also heard that there's a mediation bill presently before being considered in India. Now, mediation and litigation. In fact, almost when we look at other forms of dispute resolution, we compare it with litigation, because litigation for the longest while has become the default mode, particularly for us within the Commonwealth, particularly for us coming under British rule. That's been the default way of dispute resolution. But I've told you that some of us as the ADR advocates feel that you cannot have one dispute resolution process to resolve all manner of dispute, because sometimes you want to preserve the relationship between the parties. You want parties to feel part of the whole processes. And usually litigation does not offer you that those opportunities. The difference between the mediation and litigation is quite clear. There's a third party neutral, impartial person in mediation called a mediator. That third party in litigation is called the judge, usually, or the adjudicator in litigation. Now, the differences between mediation and litigation is found in the role that that third party plays in whether it's mediation or litigation. Mediation, the mediators have told you, cannot impose decisions on the party. It only helps the parties to facilitate the negotiation process. However, the judge in litigation, in fact, imposes a decision, or what we call a judgment, or sometimes if it's interlocutory, what we call a ruling on the parties. And that ruling or judgment almost always determines that one person is right and one person is wrong. And we all know the effects of that, which we'll be discussing, that it usually has the tendency to sever the relationship, particularly if it's personal, even if it's corporate business relationship between the parties, because one person becomes liable to the other party. So it is very adversarial. In fact, the joke is often said that even as lawyers in litigation, sometimes your clients expect you to also be fighting with the other lawyer on the other side. So the story is told of one lawyer who, after court proceedings, after litigation process, then joined the other lawyer, the opposing lawyer, in his car so he could get a lift. And then within hours or so, his clients came to office to retrieve his file on the basis that he saw his lawyer in the car of the other lawyer. And so there's so much adversarial in nature that sometimes the clients even want to drag lawyers into the whole litigation process. They expect that the same way they are cutting ties and fighting with their opponents, the lawyers should be doing the same. Not forgetting sometimes that these are lawyers that you've been working with and probably sat in the same law school with for many years. And then again, mediation and litigation. Mediation is voluntary, as I've stated. You can walk away at any time. Even for the court-referred mediation, the court cannot impose on you when it refers you to mediation to arrive at a decision or an amicable settlement. So parties are free to walk away at any time prior to the settlement of the dispute proceeding. But if somebody sues you in court during litigation and you do not appear, in fact, in Ghana, it stated that under the orders of the Chief Justice, and I believe it's the same for other jurisdictions, if you do not appear within 8 days or any other specified date, the court will proceed to deliver its judgment. It could be against you or for you. So you cannot afford not to even present yourself. And you don't choose who your judge will be. As long as you file the writ is filed against you, or you file the writ, the court process itself determines for you the judge who will be sitting, sometimes even the court. So if it's the land court, in Ghana, for instance, we have about 12 land courts division. You can be going to land court 1, it could be a judge who is female, you can be going to land court 2, it could be a judge who is male, etc. You don't have control. Parties don't have control on the process in litigation. But in mediation, parties have control as to the choice of mediator, the language to use, the process, even the settings, the venue of the mediation process. In litigation, the judge tells you you need to come at 12 p.m. next week and you have to be there, or the consequences will follow. Another difference is the formal and informal nature of litigation and mediation. In fact, sometimes parties feel, again, they feel very lost in courts. They feel very alienated. You know, they said, "Kevia temptor," you are sitting there and you say, "Look, this is just a land matter I brought here. What is this?" And I raise objection on rule, I see civil procedure rule 21, and then there's an objection and it's obnoxious. And then they are wondering where this is going from. Other than the usual ground rules of decorum and courtesy and structure that will be agreed upon by parties and the mediator. We do not have a High Court civil procedure rules and Supreme Court civil procedure rules. You have to know all the procedure rules that are associated with litigation. This again makes parties feel very limited. And then the effect of an outcome. Again, for me, that is where in Ghana, for instance, there is a similarity between mediation and litigation. Now, at the end of the litigation, the judge will come up with an award or a ruling if it is interlocutory in nature, which can be enforced by the victorious party. Now, similarly for us in Ghana, once a settlement agreement is reached at the end of mediation, the court equates it to a judgment of the court. And so you can also enforce a mediation agreement. Previously, before the ADR Act, the settlement agreements only become evidence. So you have to go through the normal litigation process like you would enforce a contract. So the settlement agreement becomes like a contract between the two of you. But with the ADR Act, Section 82 tells us that a binding settlement agreement that has been arrived at by the parties is enforceable in the same manner like a judgment of the court. And finally, let's look at some differences between mediation and arbitration. Let me also state that arbitration in some countries is also known as an ADR process. There are some countries who see arbitration also as an ADR process. Other countries also see it as different. So they call ADR an arbitration process, like UK, etc. In US, arbitration is seen to be seen as one form of ADR, because it also shares quite some similarities, arbitration, with litigation in the sense that the arbitrator or arbitrators, depending on their number, will come up with an outcome called an arbitral award, which determines rights and liabilities of the parties. In other words, the arbitrator acts almost like a judge. The difference is that the parties determine who their judge called the arbitrator is. They determine sometimes the rules where they will sit to conduct the arbitration process, the timing, and it is also usually expeditious, unlike litigation where there is a long queue. And so when you see, we're looking at the differences between mediation and arbitration, find certain similarities that's between mediation and litigation. A third party in mediation, as I've told you, there's always a third party in both mediation and arbitration. In mediation, he or she is called a mediator. There can be one or two or three. Again, the difference here between mediation and arbitration is that there can also be more than one arbitrator, but the number of the arbitrators must be an odd number, because a decision has to be taken and we can't have a tie between the arbitrators taking that decision. The role of the third party in mediation and arbitration also differs. And as I've indicated, the mediator is unable to impose decisions on the parties. However, an arbitrator is like a judge, except that it's a judge who has been taken out of a courtroom to a place and upon the conditions and the terms agreed by the parties. So the arbitrator also delivers what we call an award, an arbitral award. He determines right and wrong, that this party A, you are liable to party B, you're supposed to pay this amount of money to party B, you're supposed to pay interest on the said amount to party B. And that award is usually final and binding for most jurisdictions. For us, if you look at our section 52 together with 57, that arbitral award is binding. It is enforced in the same manner like a court's judgment. But again, the beauty about arbitration is that some people can decide to sit outside their jurisdiction, but you get to all the attributes of litigation. So there's a right and wrong. It may end up in the severance of relationship, whether personal, corporate, or business. Then there's also the voluntariness. Mediation is voluntary, as I've indicated. Up until the time of settlement, parties are free to walk away. even though it is recommended that because it is a party process, usually parties will arrive at that resolution. But if you do not appear before arbitrator after some number of times, just like a judge will do, the judge can proceed to a conclusion, and the arbitrator can also proceed to a conclusion and come up with its or the tribunal's award, which may be in favor of you, the party who chose not to, who chose not to be part of the arbitration proceedings when you yourself have agreed by way of agreement to submit to arbitration. In mediation as against arbitration, mediation is quite informal, very flexible. Parties are part of the process. There are no rigid, strict rules that have to be followed, unlike arbitration, which almost toes the line of litigation with some very procedural rules, some objections that may be raised, and quite like litigation. And so the effect of outcome is also the same for both mediation and arbitration, speaking from Ghana. Because if you look at our act, it says that once the parties enter into a binding settlement agreement during mediation, it is enforceable in the same manner as an arbitral award. And arbitral award too is also enforceable in the same manner as a judgment of court. And therefore, by parity of reasoning, the settlement agreement becomes enforceable like a judgment of the court. Let me wrap up by looking at the lacuna, the disadvantages of the adversarial dispute form of resolution like litigation, and sometimes people even add arbitration to it, and why we make a strong case for mediation. It is adversarial. It is, sometimes it breaks down relationship. It is unhealthy. In fact, the issue, again, the story is also told of the number of people who have had their high blood pressure reduced as a result of some years of litigation when they finally get closure. In fact, within the course of the period, it can even affect you health-wise, can affect you mentally, because you are in court a number of times, and the whole adversarial nature, even in court and outside the court, it's telling, and you can't even place a value on that. The fact that unlike mediation, where parties themselves arrive at a mutually beneficial settlement and amicable settlement, we do not determine that you are wrong, you are right. Sometimes the outcome of mediation settlement is that parties apologize to each other, or parties determine a very mutual soft way of in litigation. There's who is wrong, who is, I now find in favor in litigation, for instance, I now find in favor of party A, party B was wrong, was liable, and has to pay this amount of money. So it saves time and money. And here, mediation saves time and money. And here I put it together because, like I stated, if you are running a litigation, and I have handled a case before in 2014, and the case had begun in 1981. It was started by my boss in the law firm, and he had started it somewhere in 1981. As of 2014, we're still in court. Dockets have been missing, parties have died out of the process, and you cannot place the value on the time. For people in corporate bodies, if you're spending every morning or any other, even monthly, to be in court just to litigate over corporate issues, you'd rather save that time to be in court. And so the queue, again, in our courts, with so many people opting for litigation, even though now it has reduced because of the knowledge of mediation in other forms of ADR, the time and money that are wasted are expended in the adversarial dispute resolution process. It's uncountable. Then there's also the unfriendly court atmosphere. And even that experience has shown that it doesn't matter whether you could be the highest CEO in your firm. Sometimes when they visit, I've seen people who have told me, look, lawyer, this is my first time in court. We've seen people shaking in courts because the opposing lawyer wants to tear you into pieces, want to make you look stupid, want to make you drag your case in a manner where you feel even helpless. You could be the top management official in your office. You could be the most educated. The courtroom is hardly ever friendly to you. You've seen people even sweat and shake in the box as they are being cross-examined by the lawyer, because that is the training of the adversarial system. Lawyers are supposed to be adversarial to build their case, to carry their case across. We've actually seen people in some cases, mess themselves up in court, through tears, through sweat. In fact, a story again is told that if you cry in court, the other lawyer will tell the judge to take notice of the crocodile tears you are shedding. If you don't cry also, then you also tell the judge as to how guilty you are that you can't even show emotions. So what do? The courts can be very unfriendly. There's substantive dissatisfaction, as I've indicated. Sometimes some people may not want, hardly will a court, except in defamatory cases, will order that the other party apologize to the winning party. I've seen mediation outcomes where the one party only wanted an apology and nothing more beyond that, and wanted that appreciation that he had been wronged. And once the apology was offered, that was the end of the matter. But hardly will you get an apology in court. You can get monies in court. My own former boss, only wanted an establishment of the fact that he had been wrong. And so even when he was giving monies in court, he didn't follow up for the money because he wanted that statement, that principle to be established. And so sometimes you may get an outcome, but you may not necessarily be satisfied with the outcome. I've told you about confidentiality. I've been to cases where sometimes big people in societies are being round down, all their businesses is out there in the court. You don't have that kind of confidentiality with mediation. There's also improved communication with mediation because the mediator with his or her skills helps the parties to communicate because they've already come to the table, not talking to each other. But sometimes you find out that by reason of the skilled mediator in the course of the mediation, they will still patch up, they will mend their relationship. And there's a general improved communication than what they came with. Related to that is that mediation helps to preserve relationships. I do believe that very close relationships, even business relationships, ought not to be severed through the adversarial dispute resolution, but rather it is recommended that mediation where parties own the process, talk through the process without a feeling of who is right or wrong, is a much more improved way of preserving relationships. And finally, you cannot place a value on the fact that parties in mediation are part of the process. They are not lost by reason of the legal jargons and the whole court procedures and etc. And they feel part of it. And so let me thank you. I have run a bit off my time, but like I said, I look forward to answering some of your nagging questions as we go through the Q&A and to learning from you. Thank you very much.
Thank you. Thank you so much, ma'am, for such a lovely session. We'd like to go ahead with some question and answers. You can post there. So there's a question by Nasreen. Nasreen, you want to take up your question, please? Nasreen, are you there? And if anybody else has any questions, would you please write them in the chat box? We'll take them up right now. So while we are waiting for...
There's a hand raised by
Yeah.
Sorry.
Yes. It was an excellent lecture by Miss Diana. Thanks for that. I'm Jitendra from this beautiful state of Goa in India. And my question is, it is often said that there is a win-win situation as far as the mediation is concerned. It's a win-win situation, and do the parties feel happy or that dispute is resolved, or is there a feeling of resentment and having been compromised somewhere also?
Right. Do I come in or, okay, I will take some few. Anupama, do I come in as and when the questions come?
Please do.
All right, thank you very much. And let me say that I believe, yes, when you say that Goa is very beautiful, I was there. I think last year for the last Commonwealth Lawyers Association conference, and I enjoyed myself so much. So thank you. And it's true, mediation is a win-win situation for both parties. If you ask me if there's a feeling of resentment because of that party determination and ability to walk away, it almost makes it you not in prison to be part of the mediation process. And that is why mediators are also trained to continuously give that reassurance to parties. And I believe one of the topics we'll be looking at is ethics for a mediator. And so some of the ethical issues that a mediator must be aware of is the feeling and the impartiality. You need to check in with parties, whether they are with you and they are following the process and they are satisfied with the process. Because the consequence of the party feeling bad resentment is for that party to walk away before settlement is arrived at. And so that's what we talk about, a win-win situation, because parties feel part of the process. There is no reprimand. There's usually space saving in mediation process with a view to achieving an amicable settlement without necessarily saying that this one is wrong, this one is right, and this one is holier than the other person. So I hope that answers it. Thank you.
Thank you.
Next, we have a question from Desiree. Did I say your name right, please? The question is, here in the UK, we are...
Ma'am, Nasreen Fatima. Hello.
Hello.
Hello, everyone.
Go ahead, Fatima, please.
Ma'am, am I audible, ma'am?
Yes, you're audible.
I'm Nasreen Fatima from Madras High Court. I just have a question that settlement agreement under private mediation govern under which law?
I'm so sorry. I don't know if you can repeat that, please. I think I must.
Settlement agreement under private mediation govern under which law?
Right. So I can speak largely from the Ghanaian experience. If you look at our ADR Act of 2010, Act 798, if you look at Part 2 of the Act, which runs from, I think, Section 63 of the Act, you do not make a differentiation between private mediation or court mediation, or as the case may be. And so it states, without distinction, that once the settlement agreement is arrived at by parties and agreed to be binding, it is enforced in the same manner as a court judgment. I can understand that other jurisdictions may be different, but for us here, whether it's private or any other form of mediation, once there's evidence that mediation was achieved, there's a settlement agreement, then that settlement agreement is enforced like a court judgment. Thank you.
Thank you, ma'am. Thank you.
Thank you. The next question is from Desiree. She's asking, here in the UK, we are about to have a potential ruling which may or may not make mediation prior or during litigation to be mandatory. Do you believe that all countries ought to make mediation mandatory? What could be the benefits?
Right. Thank you very much, Desiree, for that interesting question. In fact, I saw it as I was looking through. There's been a debate about this compulsory mediation, and you can only look at the reasons that have been advanced for mandatory jurisdiction. Most often, one of the strongest for me arguments for mandatory mediation is that sometimes parties, whether by themselves or through their lawyers, do not want to be the ones to make the first overture of attempting mediation, but for fear of being seen to have a weaker case. It takes a lot of understanding, and I think we're gradually getting there, but we haven't got there. And so parties would rather want it to be like, well, it is the judge who said we should go for mediation. I was deep down may want to have that kind of attempt at mediation. It's one of the strongest arguments has been that we maintain it because of egoistic issues between even parties and even their lawyers. When they know in the full glare of themselves that mediation may be the appropriate way of resolving this issue, are restrained for so many reasons from making that attempt or that overture for settlement. So in my humble opinion, I think this argument holds quite sway, particularly when you realize that even though you may be compelled to go to mediation, there's still a new way out. If you are not satisfied, you can walk away. But most often than not, sometimes I think judges need to get very stubborn lawyers and clients aligned. And sometimes people are happy. Lawyers are happy that the judge even made an order for referral to mediation. But sometimes they would have been advising their clients who will be very stubborn and dogmatic and no, we are not going for mediation. So these are some of the arguments that have been advanced for compulsory mediation. Thank you.
Thank you. The next question is, how can we develop trust in the process of mediation? It's from Renalini.
Right. Thank you very much, Nalini. Yes, I believe that in developing trust in the process, a lot depends on the mediator. Don't forget, the parties already came to the table very suspicious of each other, especially if it is mandatory mediation, very cynical of the whole mediation process. And that is why the mediator skills is key. You have to have an understanding of listening skills, the understanding of questioning skills. You know, there are various questions and the opening questions, ended questions you ask clients. And of course, even your actions and inactions. Sometimes there was a play we showed when I was lecturing in the university where a party even raised the issue that the mediator was looking at the other party too much. Yes, that was an issue. That why are you focused on the other party so much and not me? Issues of time, and if I'm giving 10 minutes, the other person ought to be giving the same and not more an issue. So these are consistent, some of the few things we try to teach mediators to be aware, even the way you sit at the mediation table. If you sit so much that you don't seem to be impartial, you are more closer to the other, people may raise issues in that. It will interest you to know people raise issues about trust in very, very what you would call trivial ways. Even where you sit, the way you approach, the whole party. So there's a lot, that's a whole topic for another day, and usually arises when we're looking at ethics in mediation, which a mediator must be aware of. Thank you.
So the next question is from Sarthak Singh. Ma'am, while going through the ADR process, which one do you think is the best way of handling property disputes, basically family partition? So he wants to know, according to you, which is the best tool, mediation, arbitration, or conciliation?
Right. As I've indicated, a whole lot of factors go into determining which are appropriate for them. I've told you I started off with the hospital settings that depending on the kind of ailment or depending on the kind of dispute, very different forms of dispute resolution will be key. Now, in this, generally, I would ask for mediation because of the family involvement. So it depends on the parties who are involved, what has been their peculiar circumstances. But generally, without knowing who the parties are, without knowing the facts of the case,
आप 2 दिन से क्या कर रहे हैं? तीसरा दिन चल रहा है.
A mediation for such family partition issue because you want to preserve that.
नहीं, मैं आपको क्या करता लिंक भेज दूंगा, ठीक है ना?
Can I go on with the next question?
Please go ahead.
So the next question is from Deborah, which says, is mediation a feature of the criminal justice system in your jurisdiction? If so, can you share some of the experience there?
Right. Thank you very much. It's a very good question, and I missed that in my presentation, so thanks for bringing it up. In fact, even before our ADR Act was passed, in our Courts Act of Act 459, if you looked at Section 72 and Section 73, it gave the court power to resolve certain criminal matters that are not felonies and or are not of an aggravated nature. So it gave power to the court to also recommend to the parties to settle. And so that power is still sustained, even now with the ADR Act, which we have. And so you realize that if it's a minor criminal matter, if it's not felony in nature, or it is not aggravated in nature, the court will allow the settlement through mediation. Because other than that, any other way, any other crime that you seek to settle, it's criminal, and it's stated in our ADR Act. Now, this issue of settling criminal matters within our criminal justice system has also become topical with emerging discussions on what we call restorative justice. so that a justice process where the victim feels part of the process. So you have a setting where there is the accused person, there is the victim, and then there is the court in trying to help them through the ADR office to settle. Because the understanding is that sometimes when in criminal justice system, if we resort to litigation, the victim may not get that satisfaction that he or she requires at the end of the litigation process. Because the victim in such a case is usually just a complainant. If you imprison such a person, or if you find such a person, state that benefit. So in Ghana, it's allowed for minor offenses to be resolved through mediation. And usually what can be done is that the victim can be compensated, apologies can be rendered, as long as that offense is not a felony and it is not of an aggravated nature. So we do have that experience here where we actually settle, for instance, even if it's, again, family, if it is assault, among other minor criminal offenses, it's allowed under our laws to settle those matters through mediation. Thank you.
The next question is from Dr. Kishore. Dr. Kishore, are you asking in specific to Ghana situation? His question is the government a willing party for using mediation?
The person
Thank you.
you're calling is not answering. Please try later.
Thank you very much, Dr. Derry. By law and by practice, I will say yes. I don't know, I think there's somebody speaking.
Good, sir. Everybody please mute their lines other than the person who's asking the question. And Ms. Dapaah, please.
Thank you very much. Yes, so I can tell you, Dr. Derry, on authority that by law and by experience, we actually are willing party to, and I'll come to the law. In fact, the ADR Act does not make a distinction between private persons or government parties. And so parties, including government as a party, whether through its ministries or agencies, where there is a dispute, is also privileged or has the opportunity to use the provisions under the Act to resolve it through mediation. Now, by practice, again, because I sit in the office of the Attorney General as a Deputy Attorney General, most often than not, we also attend settlement before we actually go the full hog, either through arbitration or litigation, which you know is both adversarial in nature. Because sometimes when you look at the odds, and of course, particularly between government, suppliers and contractors, etc., we also have the same willingness to preserve relationships, to also avoid a situation where the double will be dropped down against the government with very dire repercussions. And so by law, there's nothing that stops us, even though I must also say that in the same vein, there are other statutes, like if you look at the bank, the act that regulates banks in Ghana, any disputes between a bank and the regulator who is seen as an organ of government has to go through arbitration, what we call statutory arbitration. And so by law and by fact, nothing precludes us as a government from being parties to a mediation. It all depends on you weighing the benefits, and some of the benefits I've told you at the last slide to determine whether you want to proceed with mediation. Thank you.
Thank you. The next question is from Gauri. Gauri, are you here? Could you please put forth your question? Gauri? I'll move on to the next question.
May I ask a question again?
Yes, please.
Yeah. My question is, in the process of mediation, is it a good idea or a bad idea to let the parties interact among themselves in the absence of the mediator, if the occasion arises?
Right. Thank you very much. It's a very, it has to be balanced, you know, nothing, in fact, if you look at even litigation and so for mediation as well, nothing stops the parties from engaging party qua party or party vis-a-vis party. For me, it can all even be seen as a win, particularly when they come very disconcerted about the whole dispute and adversarial against each other, you know, and usually it may help, but it can also, if not carefully considered, can also erupt into further deep deeply entrenched positions by the parties if they are not themselves embark on it in a mutual way. But I think we cannot, by way of law, also stop the parties from even engaging party per party, because even in litigation, when they have lawyers, they themselves, without the one lawyer speaking to the party without the lawyer, but party vis a party, nothing stops the parties from communicating with each other, and then coming back to the mediator at the next agenda, perhaps to indicate progress or otherwise that has been in the process. Thank you.
Thank you.
Thank you. The next question is from Neeraj. Neeraj, you want to go forth with your question?
Ma'am, is there any space for mediation in criminal law? And if so, to what extent do you think?
Right. Thank you very much. I think a similar one was asked, and I said yes, particularly now with emerging discussions on what we call restorative justice. Now, restorative justice, it looks at mediation in criminal matters, but as I've stated, for us in Ghana, you can only mediate criminal matters that are not felonies and that are not aggravated in nature, so very minor criminal offenses, because the understanding is that the whole criminal justice procedure, it's alienating. I mean, it alienates the victim who may have suffered the wrong itself. Because when you commit a crime, in most jurisdictions that I know, is the state versus the accused person. We leave out the needs, the mental, physiological needs of the victim. He's as if he's not part of the process. At best, he or she only comes to give evidence to support prosecution. So you find out that the outcome is that the victim may be jailed, and sometimes they may not want that because it's a family person or somebody close, they just want an apology, but the system will imprison that person or will sanction that person by way of penalties or fines. Now, even those fines and penalties you will find will not go to the victim, will go to the state's chest. And again, that argument has come up with why not rather allow those parties, the accused, the victim, prosecutor, to be in the same room to discuss it, to talk through the process. And perhaps some of these compensation would rather be given to the victim instead of it going to the state. And I think even gradually, even litigation, the adversarial nature is taking cue from this system through what we call the plea bargaining acts that we have. So we also have a plea bargaining act, which was recently passed last year, and nothing stops the court, the prosecutor from arriving at a plea bargain where the victim will be compensated. So yes, there is now more than ever a case for mediation in criminal matters, except that there's a line that is drawn, that crime shall not be felony or shall not be adversary of aggravated nature. Thank you.
Hello,
ma'am. Hello.
Yes, please go ahead.
My question is that what will be the role of mediation in family disputes?
Sorry, could you repeat your question?
What will be the role of mediation in family disputes?
Right. Thank you very much. I think one of the strongest arguments we have for mediation is when it comes to family and matrimonial disputes. Very strong. First of all, particularly in matrimonial matters, there are certain information that you do not want it to be out there. And also because of the closeness of that relationship in matrimonial matters and even family matters. If for me, you will ask me, like I compared the hospital settings, for family and matrimonial disputes, almost always, I believe the preferred mode is mediation because it improves communication. It helps parties to vent. It also helps to preserve that relationship, which is very key as a family unit. I think it's even stronger an argument than even you would have for business and corporate disputes. So for me, if I had my way, in fact, even before the advocacy for ADR, most judges in their own ways, for reasons best known to us now, were even encouraging parties to settle these matters out of court. When they are reported by journalists, when they are reported in the law report, there's a whole lot of businesses that is out there among the family and the matrimonial parties. So more than ever, I believe that mediation has the strongest argument. It's found in family and matrimonial disputes for the reasons I've elaborated. Thank you.
Thank you. The next question is from Naveen. Naveen, do you want to go in with your question?
Yes, madam. Hello.
Yeah, please go ahead.
Yes, madam. My question is that whether mediation is possible in front of the retired judges, that it should avoid the bias in between the mediators and the parties. So it is possible that the retired judges can be appointed to do the mediations.
Right. Thank you very much. So again, yes, it is possible. And in fact, it is advised that retired judges can be mediators, with a strong admonition to them to realize that as they sit as mediators, they must take off their cap of judge. And it has to be a deliberate effort to see yourself now as a mediator and not a judge. Now, I'll tell you what, when we started our commercial courts in Ghana, by our commercial court rules, it is compulsory that every commercial matter must go through what we call pre-trial settlement, where mediation is done. So when we started, just were doing those mediation themselves. Of course, not the same judge. So the judge, there's one judge for mediation, and then there's another judge for the trial should the mediation fail. Then the arguments came about that people were not free when they go to the pre-trial settlement conference to voice out what they want to do, because they are not sure the kind of communication that may go on between the judge sitting in mediation and the judge who will be in court if the mediation fails. And so the commercial court, filling this gap, then trained some of us who were not judges to become the mediators at the pre-trial settlement, because then people feel much more confident and assured that I'm not speaking to a judge. So there's that risk that people always feel if it's a judge or is a retired judge, she may still be having the mentality of a judge or in an adversarial setting. But we've also seen some very retired judges who have been phenomenal in being mediators, because they are conscious of the fact that when sitting as mediators, they are not judges. And they have to have the mindset, the training, and the skills of a mediator and not a judge. Thank you.
Thank you, ma'am. Thank you.
Thank you. There is one more question from Savio. Do you want to go ahead with your question? There. Do you want to go ahead with your question, please? So I'll ask another question which has been put forth. Are there any special qualities of a mediator in your mind that a mediator should possess?
Right. Thank you very much. I think I see one, Joy, but I'll still answer your question. And there are a number of skills or attributes that a mediator must possess. A mediator, even when we do training on mediation, a mediator must first of all be aware of his own or her own possible biases and work on them. And for that, I talk about issues around prejudices and preconceptions. You know, we all, as human as we are, we have prejudices, sometimes unconsciously, but you cannot afford as a mediator to have those kind of preconceptions. For instance, in Ghana, it is sometimes certain tribes are tagged with certain attributes. For instance, if it's, in fact, even in normal times, some people even think in Ghana, it's funny, but people think short people don't have patience. So when there's an issue between a short person and some tall person, he must have done it. He must have been the impatient. What am I saying? Female lawyers, for instance, let me use myself. It's better now, but previously, female lawyers, if it's a dispute, a matrimonial dispute, for instance, and the wife is a lawyer, you know, the bias that yes, the wife must have been the one who is not submissive because she's a female lawyer and she's probably taking all her lawyerly things into the home. So you sit as a mediator in your mind, you may have all these prejudices. I keep emphasizing mediators must work on their own biases and must be conscious enough that their own biases do not translate into their way. Because we found out that most often than not, these prejudices and biases have been disproven. A mediator must be a very good listener. Most often than not, certain disputants come because they feel they want to vent and they want to be heard. A mediator must listen more than speaking. And listening is not just listening, but active listening. Sometimes it's even the way you are paying attention to the party, is some nods here and there, is some appreciation, is that prodding for the party to go on. So a mediator must be a very good listener, a very good questioner. You know, you don't ask questions that, you have to ask questions that save face. You don't have to ask questions that almost emphasizes the wrong of the other party. And you usually use these open-ended questions instead of cross-examination questions. We call some things reflective skills. We call something summary. Sometimes people talk about all other non-issues and you realize that the issue is lost somewhere in the middle. So you need to check in with the party. So do I understand you to be saying this? And then you summarize the issues. You help them to tease out the issues, else parties can go all over the place in dispute resolution. And for me, most important, a mediator must be ethically compliant. Very ethically compliant on issues of privacy, confidentiality, corruption, etc. Because when ADR was being advocated, one of the skepticisms was that why would we have people who have not been trained as judges and who don't have all these ethical trainings to be resolving our dispute for us? And so you, as a mediator, one of the skills you must have is to be very mindful of your ethical obligations, not to be seen. And I've always said that we cannot always regulate the scenarios when it comes to ethics. I've always ended it with saying that as a mediator, you must not only be seen to be performing your role justly, but you must not only perform your role justly, but you must be seen so that the third party outside who is looking at what is going on will be confident that you are carrying out the process in a trust, in a fair and in a just manner. So yes, that would be for another topic on ethical, but these are some of the few I can talk about. Thank you.
The next question is from Jyoti. Jyoti, you want to go ahead with your question, please?
May I ask a question?
Yes, please.
I would like, a question is, what kind of a sitting arrangement do you recommend for the process of mediation?
Right. Thank you very much. It really depends, you know. For instance, if it is a very feisty, two very feisty parties, you don't even want them to be close to each other. Because by the time one throws a blow and you are coming in to stop the fight, they may have hurt the other party. People have talked about round tables where the environment is not so hostile, it's not so feisty, but where there has been even physical attacks in the past. You don't want to sometimes use a very rectangular table, one at the other end, so that before one throws the blow at the other, you're already in the middle to try and stop and break them apart. So usually round, but it's usually where it is not hostile, you know, and you also don't want to be, as a mediator, you are sitting like on top of a chair or a judge and the parties are below you, like we have usually in the court settings. So again, I'd say that usually round is recommended, but if you look at the security nature of it, you may decide to look at other innovative ways without seeming as the mediator that you are imposing, or that you're also aware of the security repercussions by way of physical assaults that may arise. Thank you.
Thank you.
Thank you. There are more questions, but in
ma'am, can I ask, because that
keeping in time with the line, sorry, there are more questions, but keeping in view the time, I'm just going to take two more questions. If we could ask that, please. Ma'am, are there any settlement agreements stamped in Ghana, and what is the validity of an unstamped settlement agreement?
Right, thank you very much. So for us in Ghana, with the mediations that we have, you don't have to stamp them. We have what we call an originating motion pursuant to the ADR Act. So you file an application that pursuant to the application under Section 82 of the ADR Act, and you attach the settlement agreement, which would have been signed by both parties and the mediator or mediators. You attach it as an exhibit. So we don't have that requirement of stamping in Ghana.
Thank you. And the last question I'm going to take up is that by Deborah, in some of our jurisdictions in the Caribbean region, we have introduced judicial settlement conferences, which is like a mediation conducted by a judge. Is this done in Ghana?
Yes, and that's what I mentioned started with the commercial courts. So we had another judge who is actually, and it's compulsory, no commercial court in Ghana now goes to straight trial. No, it has to go through that pre-trial settlement conference, which are mediation done by judges or any other person that's maybe used non-judges. So it's also done, but I told you about some of the skepticisms with that. The parties feel, well, even though this is not the judge who is going to try my matter if mediation fails, I'm not sure what conversation she's going to have with his colleague judge or her colleague judge over there. So they don't usually come out. They're not forthcoming, you know. And that's why the trust is not there. And that's why other non-judges have been trained to also augment judges at the commercial court. Thank you.
Thank you, ma'am. Thank you for a lovely session. You outlined the mediation process really well, where you mentioned that mediator is only a facilitator and the process allows parties to participate, unlike in litigation, where the lawyers take the main stage. I understood from your presentation that in Ghana, courts can also refer matters for mediation, just like in India. And the parties do not lose the right to litigate if the matters are not settled in mediation. It was really nice to hear from your perspective. You mentioned that the opening statement is most important to you. And I personally believe when I start with my mediations that I love to give my time to the opening statement. I believe it is the time that the mediator gets a chance, an opportunity to start building a rapport with the parties. And I think that's really, really essential. It was really nice to know in Ghana, the mediation settlement agreement is as enforceable as a court judgment. So we learned so much more about how it works in your country, and that was really nice to know. And I heartily agree with you when you said that we cannot have just one form of dispute resolution. Mediation cannot be the only one, right? We are heartily supporting mediation and promoting it, but it is apt for certain types of matters, and for certain types of matters, other mechanisms are better suited. You really highlighted very well the differences and the advantages of mediation versus an adversarial process, where you definitely cannot please everyone. And thank you so much for so patiently answering all the questions for everybody.
My pleasure. Thank you for having me. And I've learned a lot too from all of you to know that at least we share some commonalities with India, the Caribbean, and in the UK from the questions that have come. Thank you.
Thank you very much for a lovely session. I would like to thank you on behalf of Team Nivaaran, myself, and all the participants for taking out time from a busy schedule and sharing your thoughts and experiences with us. It was very insightful. I hope everyone here is more excited to join every day's programs and has learned more than what they knew yesterday. I also hope for those of you who are new to the field, these lectures will improve your understanding of the subject, its utility, and strengthen your passion to practice in this area. Before we round off, I would just like to inform that we will continue with the mediation webinar session tomorrow, which will be on communication skills needed for a mediator, which will be by Professor Andrew Goodman, and the host will be Advocate Devrat. But tomorrow we will join in at a different time, so please note it will be at 8 p.m. Indian Standard Time. Thank you so much. Thank you everyone for joining in. Thank you once again, ma'am, for having us here and for sharing your thoughts. With that, I would like to say thank you, Santan sir, if you want to add a word.
Thank you. Thank you, Diana. Thank you, Anupma, for wonderful moderating.
Thank you so much.
Thank you, everybody. Bye-bye.
Bye.